misting afternoon in Frisco, Texas. A high school track meet paused for the weather, hundreds of athletes pulling back under whatever cover they can find. And under one tent, two 17-year-olds end up shoulder to shoulder who were never supposed to cross paths that day. One of them is a team captain, an honor student, the kind of kid teachers point to. The other is the same. Captain honors an athlete with a future. By the end of the afternoon, one of them is dead and the other is in handcuffs. That part almost nobody disputes. Everything else about this case would be fought over for the next 14 months. Inside a courtroom, across cable news, and inside a single online account that would climb past $600,000. And here's the thread that never quite got tied off: that money. Where it came from, how fast it arrived, and the question a lot of people are still asking tonight: where exactly did all of it go? There's an answer on the record. There's also a gap in that answer. And the gap is the part worth staying for. But to understand the money, you have to start under that tent. And to understand the tent, you have to understand how fast a few seconds can rewrite two families forever. Quick one before we go further: drop the state you're watching from in the comments. Always curious how far this one reached. April 2, 2025. Kukendall Stadium, Frisco. A district track meet, the kind of ordinary spring afternoon that fills a stadium with teenagers in team colors. Then the weather moves in, a fine mist settles over the field, and the meet pauses. Kids scatter for cover. Austin Metcalf was there with his twin brother Hunter, 17 years old, a linebacker for Frisco Memorial, by every account the center of gravity on his team. Karmelo Anthony, also 17, ran for a rival school, Centennial. He took shelter under a tent that, according to witnesses, belonged to Memorial's athletes. What happened next took seconds. There was a confrontation over the seating under that tent. Words. Then a single act of violence that ended Austin Metcalf's life right there at a school sporting event, surrounded by hundreds of kids and coaches. We're not going to dwell on the physical details. They don't make you understand this case better. What matters is the fact, and the fact is heavy enough. A 17-year-old died at a track meet, and another 17-year-old would stand trial for murder. But here's the question that would split the country in two. Was this an attack, or was it a teenager defending himself? Hold on to that, because the answer wasn't obvious to a lot of people. And it wasn't obvious to a courtroom either. And here's what made it so combustible. Two versions of that afternoon took shape almost instantly, and they could not both be true. In one, a smaller seated kid was confronted and reacted out of fear. In the other, a teenager issued a threat and carried it out over a seat at a track meet. Same tent, same mist, same few seconds. Two stories pointing in opposite directions, and a year of legal warfare riding on which one a jury would believe. Police arrived. Anthony was identified, detained, and booked into the Collin County Jail that same day. The initial bond was set at $1 million, and almost immediately, this stopped being a local story. Because within 48 hours, two things happened at once. The internet picked a side. Actually, the internet picked several sides, and the Anthony family started raising money. Fast. Let's take the legal track first because it sets up everything. On April 14, less than 2 weeks after the stabbing, Anthony was back in court. His attorneys argued for a lower bond. A Collin County judge agreed, cutting it from $1 million to $250,000. The conditions: an ankle monitor and house arrest at his parents' home. His family posted the bond. Anthony walked out of jail that afternoon and said nothing to the cameras waiting for him. And where he went after that became its own flashpoint. Reporting placed the family in a roughly $900,000 home in a luxury gated Frisco community called Richwoods, with rent estimated around $3,500 a month. Now hold that image, because it matters later. A family that had just argued financial hardship to lower a bond, living behind a gate in a high-end neighborhood, while an online fundraiser tied to them climbed past $500,000. Those facts sat side by side, and people noticed. They would keep noticing for a year. One of his defense attorneys, Mike Howard, did the talking, and the line he drew that day would become the spine of the entire defense. He told reporters that every Texan has the right to defend themselves when they reasonably fear for their life. He called Anthony, a 17-year-old kid, an excellent student, captain of his track team and his football team. He said it was a tragedy for both families, and he said the words that this case would orbit for more than a year. There are two sides to every story. Self-defense. That was the flag the defense planted on day one. And here's why this particular case detonated the way it did. Plenty of tragedies happen at high school events. Most never leave the local news. This one did, almost overnight. And the reason is that it landed on every fault line America already fights about. Two teenagers. A claim of self-defense in a state with some of the broadest self-defense laws in the country. A black defendant, a white victim, and eyewitnesses who all came from the same school. Drop a story like that into 2025, and it doesn't stay a track meet incident. It becomes a national argument, with each side certain it already knows the ending. Now, back to that contradiction. Financial hardship in one courtroom. A fund swelling toward numbers most people never see in the same window. How do those two things fit together? Keep that question in the back of your mind, because it never fully goes away. It's still hanging over this case today. Here's where the money walks on stage. The family launched a fundraiser on GiveSendGo, a Christian crowdfunding site. They called it the official support fund for Karmelo and his family. The page laid out specific purposes for the money: legal defense, security, relocation, and what it called other necessary needs. And the donations came in like a flood. When one local writer first noticed the fund, it hadn't yet cracked $75,000. By the next morning, $150,000. By midnight, north of $200,000. Within about a week, it had blown past $250,000 and kept climbing. Eventually, it would be reported at more than $600,000. Stop and think about what that speed actually means. That's not a few neighbors chipping in. That's a national audience watching a case that hadn't even gone to trial yet, deciding with their wallets that this teenager was worth defending. Strangers across the country, most of whom would never know a single fact beyond a headline, were backing Karmelo Anthony in real time, in dollars. The fund wasn't just money. It was a scoreboard for one side of the argument. At the same time, a separate fundraiser on GoFundMe was shut down. GoFundMe removed it, citing a long-standing policy against fundraisers for people charged with violent crimes. That's not a verdict on guilt. It's a platform rule. But to people already angry, it read like one. And anger is the right word. Because for every person donating, there was someone furious that money was pouring in for a teenager, charged with killing another teenager. And here's a detail that complicates the easy version of this. Money wasn't only flowing to one side. Austin Metcalf's family had a fundraiser of their own, and it climbed to nearly $600,000 after his death. Two families, two crowdfunding pages, both pulling in numbers most people will never touch. One to bury a son, the other to defend one. That's the shape of a modern American tragedy. Even the grief comes with a donation tracker. But it was the Anthony Fund that became the lightning rod. And then a claim started spreading that would follow this family all the way to the verdict. If you want the full picture on a story like this, the parts that confirm what people think and the parts that don't, that's the whole reason this channel exists. Subscribe and send this to the one person you know who only ever saw the headline. Here's the claim. Social media lit up with the assertion that the Anthony family had used the donated money to buy themselves a brand new life. Specifically, that $900,000 home in the gated community and a new car. Some posts got very specific. People were asking whether the family had bought a Cadillac Escalade. This spread everywhere. One post tying the donations to a $900,000 home, and a brand new car pulled in nearly 60,000 likes. And it didn't stay in the comment section. Texas Senator Ted Cruz reposted it, and that repost picked up tens of thousands more. Think about the reach there. A sitting United States senator amplifies a claim, and overnight millions of people treat it as settled. The family bought a mansion with charity money. Done. So let's actually examine it, the way the people online didn't. Anthony's mother, Kayla Hayes, went in front of cameras and called the claims completely false. She said her family had become the target of lies and misinformation that put her husband, and her 3 younger children in danger. She said whatever you believe happened between Karmelo and the Metcalf boys, her younger kids and her husband didn't do anything to deserve threats and harassment. But a statement from a family member, on its own, doesn't settle anything either way. So the fact checkers went to the one entity that would actually know, the platform holding the money. And here's what they found at that point in 2025. GiveSendGo's co-founder confirmed the family had not yet withdrawn any money from the account. None of it. The funds were still sitting on the platform. Which means, in the spring of 2025, the family could not have bought a house and a car with donations they had not actually received. The fact-checking site Snopes rated that house and car claim false on exactly that basis, not as an opinion, but because the money hadn't moved. So if no money had been pulled out yet, where did the rumor even come from? Look back at that gated community home. The family was living in it. People saw a $900,000 address and a fundraiser in the hundreds of thousands. And they drew a line between the two. The reporting indicated that home was a rental, but online, that nuance evaporated. The picture was enough. So the early version of the rumor, they already bought a mansion, didn't hold up because the money hadn't been touched. Fine. But that's 2025. Notice what that leaves wide open. Because eventually, the money would be touched. Eventually, it would be spent. And that turns the question into something the spring fact check never answered. Once the family did start using $600,000, where did it go? Hold that. Because the rest of that answer doesn't arrive until after the trial. And when it does, it raises as many questions as it settles. For now, the case ground forward the way real cases do. Slowly. A grand jury indicted Anthony. A trial date was set. June 1, 2026. More than a year out from the stabbing. And in that long gap, the temperature around the case only climbed. The family said publicly they were considering relocating. Not for luxury, but for safety, because of the threats and harassment they were receiving. And the harassment wasn't theoretical. At one tense press conference, organized by an activist network, Austin Metcalf's father showed up unexpectedly and was escorted out by police. Hours after that showdown, the Metcalf family's own home was targeted by swatting, a fake emergency call designed to send police rushing to someone's door. Authorities in Jacksonville, Florida, even opened an investigation into a video in which a man was allegedly assaulted by someone claiming to be targeting people connected to Anthony's case. That's the climate this trial was walking into. Two families, both receiving threats. A public that had already convicted or acquitted Anthony 1,000 times over on their phones. And a money question that nobody had fully answered. And underneath all of it ran the part everyone was thinking about, and few would say cleanly, race. Anthony is black. Austin Metcalf was white. That fact alone was enough to turn the case into a proxy war online, with strangers who'd never set foot in Texas treating it as a symbol in an argument that had nothing to do with either teenager. Even Austin's father pushed back on that framing. He insisted the case was never about race, while acknowledging the national polarization that had swallowed it anyway. He wanted it to be about his son. The internet wanted it to be about everything else. A year of noise. And in the end, it all came down to 12 people in a courtroom in McKinney, Texas. The trial. On one side, the prosecution, led by Bill Wersky. On the other, the defense, led by Mike Howard, the man who'd planted the self-defense flag back on day one. Now he had to make a jury believe it. The defense leaned into the size difference. There was a widely discussed gap of nearly 40 pounds between the two teens. The defense built on it. A smaller kid, seated under a tent, in the mist, confronted by a larger athlete. Howard argued that Austin Metcalf had no legal right to put his hands on Anthony, that Anthony was in a public place, that he had a right to be there. He asked the jury to put themselves in Anthony's shoes that day. That's a real argument. Texas self-defense law is genuinely broad, and a 40-pound difference is the kind of detail that makes a juror pause. If the defense could make that tent feel like a corner Anthony was backed into, the whole case bent their way. Get one juror to imagine themselves smaller, seated, and scared, and you might get a hung jury. That's all the defense needed. Not innocence in everyone's eyes. Just doubt in one person's. But the prosecution had witnesses. And the witnesses told a very different story. According to testimony cited in court, multiple student witnesses said Anthony was the one who escalated. They testified that he warned Metcalf, "Touch me and see what happens," while keeping his hand inside his backpack. To the prosecution, that wasn't fear, that was a threat. A warning issued by someone who, they argued, was already prepared for what came next. In their telling, the hand in the backpack wasn't a frightened kid shrinking away. It was a decision being made. The defense had a counter for that, and it's a sharp one. Howard pointed out that every single one of those student witnesses came from Memorial, Austin's school. Austin was their leader, their captain. Of course, he argued, they'd see it through that lens. He told the jury to be on guard for that bias. It's one of the oldest moves in a courtroom and one of the most effective. You don't have to prove a witness is lying. You just have to give the jury a reason their memory might be tilted. So now you've got the whole case in a nutshell. One side says, scared kid, cornered, defending himself. The other says, aggressor, armed, who issued a threat and followed through. And the only eyewitnesses were teammates of the boy who died. How do you decide that? 12 people had to. But before they did, something happened during jury selection that you need to know about, because it may outlive the verdict itself. During the process of picking the jury, the state struck 3 potential jurors who were black. The stated reason was that they were educators. The defense objected. Under a U.S. Supreme Court rule, you cannot strike jurors because of their race, and a challenge to that kind of strike has a name, a Batson challenge. The judge, John Roach Jr., allowed the strikes to stand. The jury that would decide Karmelo Anthony's fate had no black jurors on it. File that away. Plant a flag on it, the same way the defense planted theirs on self-defense. Because that single decision in jury selection is going to come back at the very end of this story. For now, the testimony was in. The arguments were made. The prosecutor actually waived his right to open the closing arguments, which meant Howard, for the defense, was the first voice the jury heard in that final stretch. He used it to hammer self-defense one more time. Then it went to the jury, and the country waited. Think about the weight in that room. 12 people who didn't ask to be there, handed the most polarizing case in America, told to set aside everything they'd seen online and decide based only on what came through that courtroom door. One verdict would tell millions of people they were right. The other would tell them they were wrong. There was no outcome that wouldn't enrage half the country, and they had to find it anyway. On June 9, 2026, they came back. Guilty. Murder. The jury rejected the self-defense argument completely. The 40-pound size difference, the mist, the seated teenager, the broad Texas law, none of it was enough. They found that Karmelo Anthony murdered Austin Metcalf. One of the most viral narratives of the entire case, the smaller, frightened kid acting out of fear, was, in the eyes of 12 jurors, not what happened. And then came the part that hits hardest in any trial, sentencing. The judge turned to the jury and told them it was now their duty to assess punishment. The prosecution asked them to remember who Austin Metcalf was: a son, a brother, a 17-year-old who would never graduate, never meet the person he might have spent his life with. They showed an image from that day at the track meet. Coaches gathered around Austin, praying. And the prosecutor said a line built to land. Nothing the jury did with their verdict would ever take as much from Karmelo Anthony as that day had taken from the Metcalfs. The Metcalf family spoke directly to Anthony in court, delivering victim impact statements, the moment where a sentencing stops being about law and becomes about loss. And in a turn that complicates every easy narrative people had built online, Anthony's own mother testified at sentencing too. She said she loves her son very much. She said he regrets what he did. 2 mothers, 1 courtroom, both of them broken in different directions. The number came back, 35 years in prison. Anthony, who'd been 17 under that tent, was 19 now. And he sat in that chair, by accounts visibly shaking, his head in his hands, as a Texas courtroom decided he would spend more than 3 decades behind bars. The verdict answered the first question we asked, back under that tent. Not self-defense. Murder. But there was still one question the courtroom never put on the record. The money. More than $600,000 had flowed to this family. A senator had told the world it bought a mansion. So now that the trial was over, where did all of it actually go? Here's what's on the record. After the conviction, the Give Send Go page was shut down, and Give Send Go issued a statement explaining what had happened to the money. The funds, reported at more than $600,000, had been distributed over the past year for two stated purposes: legal defense and family relocation. The exact purposes the page had listed from the start. As one report put it, the money had been paid out over the year for those purposes. And with that purpose complete, the fundraiser was closed. The family told the same story in court. Anthony's father testified that the community-raised funds were used strictly for legal defense and emergency relocation, not for bond, after the family faced threats. That's their account, given under oath, and it lines up with what the platform said. So is that the end of it? Lawyers and a place to live? Maybe. But here's where being honest means admitting what we don't have. Because what nobody has produced, not the family, not the platform, not any court filing made public, is an itemized accounting. We have a category: legal defense and relocation. We do not have a ledger. How much of the $600,000 went to attorneys? How much to relocation? And was that relocation a rental, like the home reporting described, or something else? How much to security? Donors gave to a page with 4 listed purposes, and what they've gotten back is a sentence, not a breakdown. And that gap is exactly why the questions never died. Think about the 2 facts that bookend this. At the start, a family arguing financial hardship to lower a bond, while living in a gated community and sitting on a 6-figure fund. At the end, one day after sentencing, Karmelo Anthony filing a notice to appeal and asking the court for a taxpayer-funded attorney, describing himself in that filing as a penniless, destitute, and indigent person too poor to employ counsel. Sit with those 2 bookends. A fund that crossed $600,000, and a young man who, the day after his sentence, tells a court he can't afford a lawyer at all. Both of those things are on the record. What's missing is the middle, the line by line that would show, dollar for dollar, how the one became the other. No one has shown that middle, and until someone does, the question stays alive. Now, there are completely ordinary explanations, and an honest account has to put them on the table. A high-profile murder defense, running well over a year with a full trial and expert work, can consume enormous sums. Top criminal defense work is not cheap, and a case this size could burn through that fund on legal fees alone. Relocation and security for a family facing documented threats cost real money, too. It is entirely possible that $600,000 went exactly where they said it went and simply ran out. That is a normal outcome, not a suspicious one. But it's also fair to say what hasn't happened. No public accounting has been released, and the more pointed version of the rumor, that money was diverted to personal enrichment, was never actually proven. When Snopes revisited the claim in 2026, they didn't confirm it and they didn't bury it. They left it unrated, citing a lack of sufficient evidence. Not true, not false, unverified. So where does that leave us, honestly? With a documented answer that is also an incomplete one. The people closest to the money say it went to defense and relocation. The platform backs that. There is no public proof it went anywhere else, and no public proof, in the form of a detailed accounting, that it all went exactly where they say. Those can both be true at once. And that's the uncomfortable middle this case actually lands in, no matter which side of it you came in believing. What we can say cleanly is this: the fund is gone, the page is closed, and the young man at the center of it is now telling a court he's indigent. Whatever the full breakdown, the money did not buy an acquittal, and it did not buy a way out. And what comes next is the appeal. Anthony's lawyers say there are several issues they believe the appellate courts should consider. One Texas defense expert, watching from the outside, told the New York Post the family is likely going to throw the kitchen sink at the appeal, meaning they'll raise every issue they can and hope one sticks. And remember that flag we planted earlier. Those 3 black jurors struck during selection. The objection the judge overruled. Court records haven't spelled out yet whether the appeal will formally be a Batson challenge over those strikes. But here's why it matters. That Supreme Court rule exists for one reason: A jury is supposed to be chosen without regard to race. And if jurors are struck because of it, a conviction can be thrown out and the case retried. The state's stated reason was that those jurors were educators. The defense didn't accept it. An appeals court might not either. A conviction this size can hinge on whether a jury was chosen the right way. Not on whether the defendant did it, but on whether the process was clean. That's the strange power of an appeal. It can undo everything on a point the public barely noticed. That means this isn't over. A teenager is dead. Another will spend his best years in prison unless an appeals court says otherwise. Two families remain locked in the worst thing that ever happened to either of them. And a case that split the country over self-defense, over race, and over a tent in the mist is going to keep splitting it for years. And the money question stays open with it. Not as an accusation, as an accounting. Hundreds of thousands of dollars came from strangers across the country, and what they've been given in return is a category and a closed page. Maybe that's the whole story. Maybe a full ledger would show every dollar exactly where it was promised. But until that ledger exists, the most honest thing anyone can say about where the money went is, here's what they told us, here's what we can confirm, and here's the part we still can't see. The verdict answered the question we started with, back under that tent. The money question, it turns out, is harder to close, and the appeal could turn on that jury selection fight. The three struck jurors, the overruled objection, the technicality the public barely noticed. When there's a ruling on it, we'll break down exactly what it means and what it could do to this conviction. So subscribe, and you won't miss it. Because in a case this loud, the quiet questions are the ones that end up mattering most. And this one isn't finished asking them.